I gather Ms. Hale is going to argue for both appellants. Is that true?
Yes, Your Honor. Marion Hale. We represent Robert E. Schmidt Jr., but I have been asked to argue on behalf of both appellants.
Of course. Okay, great. That makes it easy. All right. I've had it.
Thank you. May it please the court, I'd like to reserve 5 minutes of my time for rebuttal.
Sure.
Your Honor, back in 2005, an entity called Boulder Venture South entered into a contract with the plaintiff, appellee in this case, John Sabo. And that agreement that they entered into, called the Amended and Restated Independent Contractor Agreement, has made 3 appearances before this court, this being the third. The first was a case called Boulder Venture South versus, it was called Mr. Sabo versus Boulder Venture South and Mr. and Mrs. Schmidt. That is called the 2009 litigation in our brief. And that resulted in a judgment against Boulder Venture South for $5.4 million. The second time this contract came before the court was in a case called KB Brooksville and Boulder Venture South against Mr. Sabo. And that resulted in a judgment against Mr. Sabo for $2.9 million. And that was affirmed by this court. This is the third time. And in this case, Mr. Sabo has sought the $5.4 million judgment that he obtained in the 2009 litigation. He has sought to hold Mr. and Mrs. Schmidt liable for that in what we call the 2015 litigation. There are 6 separate reasons why you should reverse this decision. And the 2 first reasons are collateral estoppel and res judicata, because this case was brought and could have been brought in the 2009 litigation. In 2009, Mr. Sabo sued the Schmidts personally in count 1 of a complaint. And in count 1, he alleged that they had breached that amended and restated independent contractor agreement. And the only basis for that theory that they breached that contract could have been the document called the consent enjoinder, which is a 1-page document attached to the 2005 agreement. Because neither Mrs. Schmidt nor Mr. Schmidt signed the 2005 agreement in their personal capacities. Mrs. Schmidt didn't sign it at all, and Mr. Schmidt only signed it in his corporate capacity. So the only basis for liability in the 2009 case in count 1 for breach of contract could be based on the consent enjoinder. Now, Mr. Sabo had various theories in count 1 for that breach of contract, but they all boiled down to the fact that he believed that the Schmidts were liable to him for the debts of Boulder Venture. Now, that debt could have been based on his theory that he was entitled to the $5.4 million because he had been fired from Boulder Venture, or he had another theory, which was that he was also entitled to the net income from the property owned at issue, and that he should be paid that. That was in count 1, which was dismissed involuntarily at the close of the plaintiff's case. He then amended count 1 so that it only alleged that he was entitled to the $5.4 million, which was the 30% interest in the value of the mall. So his entire claim against the Schmidts had to have been based on the consent enjoinder, and the consent enjoinder, which he claimed was a guarantee. He did not prevail on that in the 2009 litigation. Judge Day, Jack Day, who heard the 2009 litigation, ruled that he had failed to prove his case against the Schmidts in count 1. He prevailed on count 3 in that case, in which he obtained declaratory relief against Boulder Venture. And then he sought in supplemental, an motion for supplemental relief. He obtained based on the declaratory relief, he obtained a judgment for money damages against Boulder Venture. He sought to obtain money damages against Mr. and Mrs. Schmidt in that motion for supplemental relief. The court declined to do that. He did not appeal to this court either the decision on count 1 denying him relief or the decision denying him relief against the Schmidts on the motion for supplemental relief. He also attempted to obtain relief from them in the 2009 litigation on a motion for clarification and yet again on a motion to ask this court to send the case back down to the trial court so he could once again get relief against the Schmidts. All of those efforts proved to be unfruitful. While that case was on appeal, the 2009 case, and he had no relief against Mr. and Mrs. Schmidt, he filed this case, which we call the 2015 case. And in that case, he brought the exact same claims against the Schmidts. He said they were responsible for the debts of Boulder Venture. He then fashioned it slightly differently, and he said failure to pay the final judgment from the 2009 litigation. But it is the same theory. It's the same debt. It's the same agreement. It's the same consent and joinder that would make them liable. And it is asking them to be responsible for the debts of Boulder Venture South. This is classic res judicata. It is classic collateral estoppel. It is classic splitting causes of action. So he is filing the 2015 case to correct the error that he made in the 2009 litigation, which was not to join Mr. and Mrs. Schmidt in count 3, which was the count for declaratory relief. Had he joined them in count 3, presumably he would have gotten a claim, a judgment against them for declaratory relief as he had for Boulder Venture South. And presumably, therefore, he would have gotten a judgment against them for money damages as he did for Boulder Venture South. And we know that Judge Day believed that the Schmidts had guaranteed the debt because he put into his final order and final judgment a sentence which said that the Schmidts had guaranteed the debt. And in fact, that is the sentence when this court partially reversed Judge Day. The only thing that this court did was to instruct Judge Day to remove that one sentence which said that Mr. and Mrs. Schmidt had guaranteed the debt because there had not been any evidence during the 2009 trial that they had personally guaranteed the debt. They had not actually introduced any evidence that Mr. and Mrs. Schmidt had signed the consent and joinder. So this court, sent the case back to Judge Day and told Judge Day to remove that sentence, which he did. So it's either collateral estoppel that it was tried, or it is res judicata that it could have been tried. And we know that this is
your client's position would have been, even if there had been evidence back then, that it still wasn't a guarantee, that it was a consent and joinder. But this court previously ruled it didn't even make it to that level, and we removed that language, correct?
Correct.
Okay.
Yes. The other issue, and one of the other issues, is that there's a set-off here. Boulder Venture has a $2 million judgment against Mr. Sabo. The trial court in the 2015 case ruled that our client was stepping into the shoes of Boulder Venture, an entity it owns, that they own. If they're stepping into the shoes of Boulder Venture is absolutely entitled to a set-off. It has the right, both by its agreement with Mr. Sabo and by common law, to a set-off for the $2.9 million that Mr. Sabo owes Boulder Venture. And it's undisputed that he owes it. So if they're stepping into the shoes of Boulder Venture, then they too are entitled to that set-off. The trial court said they were not, but did not give any reason for not giving the set off. The next reason is the statute of limitations. For a written agreement, we all know it's 5 years. Mr. Sabo was fired by Mr. Schmidt in 2007. Now, 5-year statute would run from December of 07 to December of 2012. This case was filed, obviously, in 2015. The trial court found that the statute of limitations ran from the entry of the final judgment in the 2009 case, which was in 2014. But the final judgment, all it did was determine when it was payable and the amount. But we know from Florida law that the statute of limitations on a breach of contract doesn't run from the time it is payable, and it doesn't run from the time that the amount of damages are calculated. It runs from the breach, and that's in the standard jury instructions and it's in the law. So it's not the time in 2014, it is back in 07 when Mr. Sabo is fired and Boulder Venture does not pay him the amount of money that he is owed, he claims he is owed. So that is a 5-year statute. Now, the first time—
Mr. Heller has cited a couple cases, the Tech Packaging case and the Joseph versus Okilanta cases. Can you differentiate those if you can as to why we shouldn't follow those?
I don't remember those cases off the top of my head.
Well, the Tech Packaging was the one where Attorney Hanchett with the Trenum firm had dealt with, it was a malpractice issue. Does that refresh your memory?
I'm sorry, it does not refresh my memory. But malpractice cases are not breach of contract cases. And in breach of contract cases, the law is that it is not from the damages, it is from the breach. And malpractice cases, it may well be, because it's a tort claim, it may well be from the actual damages. But from a breach of contract, we know that that's the statute runs from the breach. It does not run from the damages.
Okay, thank you.
The guarantee, was drafted by Steve Hudoba, a well-known real estate lawyer from the Hill Ward law firm. He had drafted thousands of guarantees at that time. He testified that he was never asked, he was never consulted about drafting a guarantee in this case. Mr. Schmidt testified that he never signed a guarantee unless he was borrowing money, and that he had never asked his wife to sign a guarantee at all in any business dealings whatsoever. Mr. Sabo testified that, quote, a personal guarantee would have been better, but this is what I got. So none of the three principals who were involved in this case, and the man who drafted it, none of them thought that it was a personal guarantee. There's no mention of a guarantee in the consent and joinder. There's no mention of a guarantor. There's no mention of a debt. There's no mention of who is liable for whom. There's no mention of who is to be paid. So the question then is, what is this document? And I think it's pretty clear what it is that there were to be future deals between these parties, and that is mentioned in the amended and restated independent contractors agreement. Future deals, but those entities had not been created. Mr. and Mrs. Schmidt would do future deals, and they would always create LLCs, always with the initials KB in the front of them. And they would be KB Brooksville, KB Tyrone, another entity you've had an appeal with. And each time they had a separate LLC. Those entities didn't exist, so they couldn't enter into this agreement. So the purpose of this consent and joinder, which the testimony was at trial, was to have Mr. and Mrs. Schmidt, who would be 50-50 owners and all of those LLCs, that they would agree that those entities would abide by the terms of this amended and restated independent contractors agreement, which would agree to pay Mr. Sabo the percentages of the deals that are set forth in the amended and restated independent contractors agreement. not that Mr. and Mrs. Schmidt were going to be personally liable. After all, they had set up an LLC to protect them from personal liability here. And the reason they did that, of course, was so that they would not be personally liable. And it would make no sense to sign a personal guarantee when you set up an LLC to protect yourself from personal liability. And the final reason here is that the trial court denied a jury trial in this case. Now, when this case had been assigned to
just a note, Ms. Hale, you are down to your 5 minutes, so use them as you wish.
I'll be really quick now.
Yeah, go ahead.
The consent enjoinder does not have any jury trial waiver language in it. A jury trial waiver has to be explicit. The only jury trial language here is for Boulder Venture South, and that is in the amended and restated agreement. And all our clients did was to sign a consent enjoinder to it. They have never waived their right to a jury trial. Thank you. I'll reserve the rest of the time.
Got about 4.5 minutes.
Thank you.
Mr. Heller?
Good morning, Your Honors. My name is Sam Heller, and I represent John Sabo, the appellee in this case. I am going to argue in response to some of the points raised by Ms. Hale, but I'm going to take it a little bit out of order, and we are asking that this court affirm the trial court's final judgment for the following 4 reasons. And to the extent that I may not get to all of the arguments that are laid in the brief, we would just ask that the court incorporate the arguments laid out in the answer brief. I want to start with the consent enjoinder. And I want to touch upon some of the arguments that Ms. Hale made with respect to what the testimony was and what the proper role of that testimony was at trial. I would submit to this court that there could not be more unambiguous language than the language contained in the consent enjoinder, giving it its ordinary and plain meaning and looking it against the contract as a whole. And it states that the undersigned, Robert E. Schmidt Jr., individually, and Kelly C. Schmidt, individually, hereby join into and acknowledge, agree, and consent to the terms and provisions of the amended and restated independent contractor agreement dated effective December 1st, 2004, by and between—
Mr. Heller, how is that a guarantee?
Your Honor, what it says is that they agree to be fully bound, all of the terms and provisions thereof. And
okay, but that's different than a guarantee. That's a joinder.
It's a joint. Yes,
it's a consent enjoinder, which is completely different than a guarantee. So how is it, you know, maybe in 2009, joining them as parties would be appropriate. But in 2015, to come back after the fact and say, this was really just a guarantee. We now want you to pay the $5.4 million judgment. How, in looking at that agreement and using your words right there, that this is a simple, straightforward document, a guarantee has certain elements that are included in a guarantee. Any attorney worth their salt knows how to draft a guarantee. We know what guarantees look like. This does not have the elements of a guarantee. Explain to us how we're supposed to go back and make it a guarantee.
Judge Stargell, I think you're touching on 2 separate issues. One is the res judicata and the collateral estoppel arguments that Ms. Hale is raising, and the second is the form of the document itself. And so I'm going to answer the form of the document itself, and I'll go back and talk about Ms. Hale's arguments with respect to the res judicata and collateral estoppel. Although the words personal guarantee are not included, and although this is not in the form that one would typically see that would be either acceptable by a bank or something that would be of that nature, the words that are used here says, and I agree with Your Honor, that it means that they are parties to the agreement, same as Boulder Venture. They are obligated to Mr. Sabo in the same fashion that Boulder Venture is. And when we look at what the arguments are with respect to res judicata and collateral estoppel, we really have to look at—
Mr. Heller, before you go into res judicata and collateral estoppel, as I look at the consent enjoinder, you have just argued that they take the position of Boulder. Where does it say that in there? It just says they agree to the terms. I can't tell if they agree to be bound as an independent contractor or the financer or whatever. There's no language that identifies what their role is going to be.
Your
They
Honor,
consent to all the terms. Does that mean both those corporation entities get to sue them?
Your Honor, respectfully, it names them in their individual capacity. Robert E. Schmidt Jr. individually, and Kelly.
And it says they agreed to the amended and restated independent contract between the two other parties and to be fully bound by all of the terms. Does that mean they are both the contractor's terms and the financier terms? It says all. Isn't that what all means?
Your Honor, all means all, and there are no financing terms in the agreement. All of the obligations are with respect to Boulder.
So
and
by signing this, they're guaranteeing for both Boulder, and they are also guaranteeing for the Sabos. They're guaranteeing from both parties' performance, in a sense, is your argument.
They're guaranteeing all of the terms and conditions with respect to Boulder Venture.
Okay.
That also includes the future projects provision that Ms. Hale asserts that this section is limited to.
I understand the argument. I'll be thinking about it.
Looking at the res judicata and collateral estoppel arguments that are raised, they really all focus on the same thing. What was the cause of action brought? What was adjudicated in the 2009 litigation? And what is the effect of that on the ability of Mr. Sabo to bring this action that we're here on today? And it all starts with section 95.03 subsection 1, which states that a cause of action accrues when the last element constituting the cause of action occurs. And when we look to the medical jet case and we look at the technical packing case, we know for a claim of breach of contract, that refers to the date of the breach, not necessarily the date of the damage, but the date of the breach itself. And so when we look at what was pled and what was decided and ruled upon in the 2009 case, we look at count 1, which was for breach of contract. Count 1 for breach of contract was against the Schmidts as well as against Boulder Venture South. And in count 1, what was pled up through the time of trial was that there was certain requirements of the contract that needed to be performed, was required in order to determine and establish the amount of compensation due to Mr. Sabo, as well as when that compensation was due and payable.
It was clear at that time, they had made it clear that there was not an intent to pay. So your client knew there was an issue he had to move forward with.
Correct, Your Honor. And specifically, the Schmidts contended that the timing of payment, they denied that any compensation was due at all. But as to the timing of payment, they maintained that the compensation, if any, that was due and owing was not due until either the mall was sold or until the death of Mr. Schmidt. And there's a time period after death that amount is payable. In your
brief, you argue that until the time of payment and amount due were known, that the statute did not begin running. Is that accurate? Is that what your argument is?
What we are arguing, Judge Sargel, is that the argument in support of involuntary dismissal was that there could be no breach because the cause of action wasn't right. That until the court made a determination of what the amounts due and payable were, and when
you were asking for declaratory relief, couldn't you have asked for declaratory relief for them?
Your Honor, at the time that the count for declaratory relief was filed, there was already the breach of contract claim that was pending. The issues that were in dispute at that time was not whether or not the Schmidts were personally liable under the agreement. Paragraph 31 of the complaint alleged that they were bound by all the terms and provisions of the contract, and that had been admitted. What we were arguing about insofar as the uncertainty of the parties' respective legal rights were, again, the costs, the actual costs of developing the mall, how that reconciled and how the calculation of compensation was made, and what the timing of payment was. And so the arguments, the entirety of the arguments in support of the Schmidts' motion for involuntary dismissal of count 1 was not based upon the fact that they couldn't prove the Schmidts personally guaranteed, as Ms. Hale suggested. In fact, when this court struck that language of the guarantee from the final order and declaratory judgment, it made specific reference that the resolution of count one was not based upon a guarantee finding. It was the finding.
Isn't that because the language that's there on the consent and joinder, there was no evidence to show it was a guarantee. There was no evidence put forward of parallel evidence at the time as to what it meant. And the language itself didn't evidence a guarantee. So this court previously struck the judge's finding that it was a guarantee.
What this court held was that although the trial court's resolution of count one was not based on a guarantee finding, what the argument was in support of the involuntary dismissal was solely the issue of ripeness and that the cause of action didn't accrue. And if we look at Appendix 6 to the appellee's brief, it contains all argument raised by Ms. Hale in support of the motion for involuntary dismissal. And what she argues is, count one, you cannot have a claim for breach of contract until there could be performance of the contract. And there's a failure of performance of the contract, and therefore there's a breach. But since the contract itself created this situation in which there is an appraisal and there are costs determined, and the parties have gone through that process, there cannot be performance of the contract. And so the contract by itself has created the situation, and the parties, by performing the contract, they are performing the contract by being in this courtroom and by asking you to determine what the costs are. And you can't have a breach because what would the breach be? Failure to pay what? We don't know that there's any money owed. We don't know when it's owed. The arguments, and this was supported by the fifth affirmative defense that was raised to the complaint, is solely that that cause of action was not ripe. It had not accrued. And so the court involuntarily dismissed with the finding that there was no breach that was demonstrated. And the only basis for that was the argument that the claim was not ripe. And if the claim was not ripe, and that is the basis for involuntary dismissal, that's an involuntary dismissal without prejudice. And when that cause of action accrues, Mr. Sabo has the right to bring that claim back before the court. And specifically, and to highlight that, again, it's important to recall that at the time that the court was determining the declaratory judgment, the Schmitz were arguing that, in part, compensation, if any, wasn't owed until Mr. Schmidt died. If Mr. Schmidt died tomorrow.
If the court ruled that at the time, could you not have appealed that? I mean, if you felt like it was ripe in your argument, you were going forward against the Schmitz, court ruled otherwise, could you have not appealed that at that time, but you chose not to? Is that correct?
Your Honor, I certainly could have appealed that. However, and going back again, at the time that I come into this case, the only things that were pled were the breach of contract count. You have the affirmative defenses raised related to ripeness. And we placed the declaratory judgment count understanding those arguments. And at the end of that trial, and based upon the judgment that was issued, we felt that the final order declaratory judgment declaring that the money was due and payable, not just payable, but due as of the rendition of that final judgment, that is when the cause of action accrued. That is all of the arguments that were raised by Ms. Hale. And so whether we decided to appeal that issue or whether we decided to move forward on it with a new cause of action based upon this claim that is now ripe, again, based exclusively on all the arguments raised by Ms. Hale, that is why we brought that claim at that time. And so count one, the issue of the guarantee was never litigated. There was no adjudication on the merits. Talking for a moment about some of the testimony that was presented, and again, the court found that the language of the guarantee was unambiguous. And so notwithstanding the ruling that on the third motion for summary judgment that the language was unambiguous, the court did permit the presentation of testimony. And so when we talk about Mr. Hadoba, what's important for the court to note with respect to the testimony of Mr. Hadoba is that Mr. Hadoba did testify that he was never asked to prepare a guarantee. He was never asked that he had never been asked by Mr. Schmidt in the past to prepare a guarantee. But what he also testified was that at some point, Mr. Sabo requested with Mr. Schmidt that that document be sent in Word because the parties were going to modify and tweak it from there. And he ultimately testified that he never saw the final form of what was executed between the parties. So he could not speak to whether or not that the consent and joinder was the same form of document that he may or may not have prepared. Additionally, with respect to Mr. Schweitzer, he testified solely as to what a bank may accept as the form of a personal guarantee. But what he very clearly testified to is that he is not opining about what an agreement may or may not stay and what would be or would not be valid as it relates to private agreements between parties. And so, Judge Casanueva, with respect to your questions and your points regarding the language of the consent and joinder, we did name them in the breach of contract count at the time, trying to seek responsibility for payment. But as it relates to the declaratory judgment, not every denial of every allegation constitutes a bona fide issue that is proper for declaratory relief. At that time, the issues for declaratory relief were the issues in the performance of the hoops that needed to be jumped through in order to establish the amount of compensation. There was no defense raised that the Sabo had failed to join an indispensable party. There was no motions or anything directed at that count with respect to other issues that were ripe for a declaration. And in fact, the Schmitz did assert counterclaims in that case that were ultimately dropped. And never there did they seek to assert or establish a declaration from the court with respect to what that consent.
Who do you think should have filed a motion to join an indispensable party?
What I'm saying, Judge Stargell, is that if the Schmitz believed that that they were necessary and indispensable parties to the count for declaratory relief regarding their personal liability, since that had been pled in count one, that was not an issue that was raised.
Why would they join? No, never mind. You go ahead. If they don't see themselves as being responsible for it, I don't understand why you would argue they would join in.
Well, I'm not saying
that
to be
they joined
necessarily needed to. I agree, and we didn't feel that they were required to be in count three for the issues that we were seeking a declaration of. Again, we already had them included in count one for payment. It was the claim for payment that the court determined that plaintiff did not demonstrate a breach. And he found that the court did not demonstrate a breach based exclusively and solely on the argument that the claim was not ripe. There could not be a breach until the court made a determination of the parties' respective rights. And that is from the argument, that is what the court agreed. There was no other basis for that argument other than the ripeness, which is contained in Affirmative Defense 5 to that 2009 complaint. And if the court involuntarily dismissed based upon ripeness, that's a dismissal without prejudice because the cause of action had not accrued. And to the extent that there's a question regarding whether or not the involuntary dismissal was or was not based upon ripeness, that burden, that obligation is on the proponent of the defense of res judicata, not to create speculation. And that comes from the North Shore Realty case that we cited to this court. The proponent, to the extent that there's a question over what the basis or grounds for a ruling or a dismissal was, if a party is asserting res judicata, the burden is on them to establish by clear and convincing evidence what the grounds for that dismissal was. They have not done that. They want the court to follow, they're asking the court to disregard the arguments that were advanced in support of that. Judge Day did not disregard the arguments about ripeness and make the determination on other grounds. Ms. Hale suggested it was because, and she stated, the Sabo had failed to prove a case against the Schmitz in count one. That is not so. That is not what the final order declaratory judgment says. And so again, to the extent that there was a disagreement between the parties based upon the ambiguities created by the documents, that was related to timing, amount, and trigger for payment. We did name the Schmitz in count one, seeking the actual damage, the actual relief. Now, if Schmitz were named in count three, conceptually, could supplemental relief have been brought against them? Perhaps. But again, when we look at whether or not the cause of action had accrued, The breach is what is important, and I could have pursued it in any form. I could have pursued it in supplemental relief if they were named, and I could have pursued it in a new claim. If the dismissal was with prejudice, again, based upon a finding that the Schmitz had not guaranteed, then that would be an entirely different ballgame. And yes, this action would be barred by res judicata, but that is not the case. The other points that I'd like to mention to the court, unless the court has any further questions on those issues, is with respect to the striking of the jury trial. Again, if the Schmitz individually are bound by all the terms of the agreement, same as Boulder Venture, then it only, then all means all. And both parties are bound by a jury trial waiver in any action arising under the agreement. With respect to the set-off, if I can just speak to that for a moment, this case decided by the Schmitz are correct in that a principal or a guarantor stands in the shoes of the principal and has any and all affirmative defenses that it is entitled to. However, the principal here is Boulder Venture. Here we're talking about a separate, unrelated entity named KB Brooksville. KB Brooksville is not a party to the independent, to the agreement. It's not referenced. It's not noted. There is nothing in that agreement that talks about what the relationship between those parties are. And so there was no testimony of any kind or argument about why the Schmitz should be entitled to defenses, not of the principal company under the agreement, but of some other entity on some other basis, even if it all flows up to the same agreement. There was no.
Mr. Heller, you are closing in on your 20 minutes, so you could.
Thank you. Unless your honors have any further questions, we would just simply rely upon any arguments that are in the brief that we have not been able to raise here today.
Thank you. Ms. Hale?
Yes, Your Honor. I'm back to the same argument that I had before. He could have joined Mr. and Mrs. Schmidt in count 3 on the declaratory action in the 2009. He did not do so. That led to him having a judgment for damages against Boulder Venture. He certainly could have had a judgment against them for damages, just like he had for Boulder Venture. He tried to get that. He asked Judge Day to give him a judgment against the Schmitz pursuant to count 3. He asked for that. He just hadn't named them in count 3. And Judge Day didn't give him a judgment against the Schmitz because he failed to name them in count 3 and said no, and denied that motion. And he did not appeal that decision in the 2009 appeal. He didn't appeal the denial of count 1, which was, by the way, not based on ripeness. In fact, what Judge Day found was that the plaintiff failed to demonstrate that the contract had been breached, did not find it based on ripeness. And that is a decision on the merits, and that's exactly what you need for res judicata and collateral estoppel. And the reason he found that was there was no evidence. He failed to introduce any evidence that Mr. and Mrs. Schmidt had signed the consent enjoinder. He never called them to the witness stand. So he had no evidence of that. And he had no evidence of it. And therefore, that's what happened. He got that claim wasn't dismissed for lack of ripeness, which it might have been at that case. He might have had an argument here. Instead, it was found failed to demonstrate the contract had been breached. Therefore, he finds himself in a position where he has no claim against the Schmitz for damages because of the way he set up the pleadings, and he doesn't appeal. He could have appealed count 1. He could have found himself, he could have appealed those post-judgment orders in which he tries to get damages against the Schmitz, and he doesn't appeal those. And then he turns around and says, oh, but I can go and I can go against them in a new case. That is the ultimate of splitting causes of action. That's exactly why the doctrine of splitting causes of action exists. His contention that the KB Brooksville judgment is completely, has nothing to do with this case. Boulder Venture was a party to that entity. Boulder Venture, to that case, Boulder Venture holds that judgment. So it's not like there's no connection between the two. Boulder Venture has that judgment. And KB Brooksville is, of course, an entity owned by the Schmitts. And finally, the Tech case that we were talking about earlier, that is a case that supports our theory, in which it says that a breach of contract, the statute of limitation, the cause of action starts when the breach occurs. There are 6 very good reasons to reverse this case, the final judgment here. Our clients did not knowingly give up their right to a jury trial, and they have to knowingly give that up. And there's nothing when you sign that consent enjoinder, which, as Judge Stargell mentioned, is a very typical document that you can sign in a real estate development deal, that there's no reason to think you were giving up your right to a jury trial at that point. There's res judicata, there's collateral estoppel here, and there's no reason that they would have thought that they were giving up their right to a jury trial. It should be reversed on those grounds. This is not a guarantee. There's no mention of a guarantee here. No mention that they're going to be required to answer for the debts of Boulder Venture. And as Judge Casanueva mentioned, are they guaranteeing the obligations of Mr. Sabo? Are they going to build the mall? Because that was the obligation of Mr. Sabo. Mr. Sabo is not contending Mr. and Mr. Schmidt had the obligation to go out and build the mall. And the statute of limitations clearly began in 2007, and he is 2.5 years past the statute of limitations. So we ask you to reverse. Thank you.
Thank you, Ms. Hale. Thank you all very much. In order to leave the virtual courtroom, you need to click the leave button in the lower right-hand corner of your Zoom screen, and then you'll be gone and we can call the next case.
Thank you.